Bionca Ellis is 34 years old. She has no felony convictions. She has suffered from mental illness since the age of 22, diagnosed with schizophrenia. And Bionca has been treated on an outpatient basis at a place called Murders Taylor for almost 10 years. There's been a lot of ups and downs as it relates to her treatment. You'll hear from her mother, Yolanda Eggleton, and she'll come in and she'll testify the struggles of trying to get Murders Taylor to medicate Bionca, because Bionca, when she's on her medication versus when she's off her medication, she's two different people. And she pushed hard for Murders Taylor to try to do something about Bionca being on medication. And Murders Taylor's response was, she doesn't represent a danger to herself or others, so there's nothing that we could do. She'll tell you how she lost contact with Bionca over the course of 6 to 8 months prior to this incident. And I'll tell you that no one's going to dispute, the evidence will show that she's a mentally ill person. Between January of 2024 up until the date of this incident, June 3rd of 2024, Bionca was off of her medication. The medication, the evidence will show, stabilizes her. Bionca received a Social Security check. And what she did with that check was she traveled from the state of Ohio to the state of California. She traveled from the state of California back to Ohio, and then down to Florida, and eventually back to Ohio. During that time frame, there were many occasions where Bionca exhibited mental illness. There were occasions where she would go to a particular location and try to get herself arrested because she's living in a homeless shelter, because she's living on the streets. She's trying to find structure. I think the evidence will show that during her mental illness, she tried to find places of refuge, unsuccessfully. On June 3rd of 2024, this unfortunate tragedy occurs. Just a few days before, Bionca was in the North Olmsted jail.
All right, we'll hear more from the defense in just a minute. Let me bring in our guest for this hour, attorney and former prosecutor Randolph Rice. Randolph, great to see you as always. Thank you so much for joining me on this Monday. First and foremost, let's start with what we heard from the prosecution. Now, we know this is a case where it's not guilty by reason of insanity is what the defense is claiming. But the picture painted by the prosecution, very compelling. It basically said, look, she went and picked the knife, then she picked the victim, then she tried to get rid of the knife before she was arrested. All those things suggest someone who is perfectly in their right state of mind. What do you make of their argument?
Yeah, Michael, that was really smart that you pick up on that. I think what she was saying, and she said at the very end of her opening is listen to the words and watch the actions of the defendant. And that's going to be their counter argument to this not guilty by reason of insanity claim that the defense is going to be making. Words and actions, those are what is going to be important for the prosecution to get over that claim by the defense.
Now, we've seen lots of cases here, Randolph, where NGRI, or not guilty by reason of insanity, is argued by the defense. The ones that are successful seem to have the building blocks that we seem to have here. Someone who has struggled with it over the years, has a diagnosis, someone who needs drugs to function in society, someone who was not on their drugs that day, and someone who does something. Because when you look at it from sort of afar, you take away some of the real tragic elements of it, the fact that a child was killed, a mother was stabbed, for no reason at all, no connection at all. It really is one of those things where it kind of speaks for itself. Who would do that except someone who was in a psychotic state? They have experts, they're going to go against each other. What do you make of that? This idea that there are the building blocks here for a case that could find success in NGRI.
Yeah, and this is going to be a case of the experts. It's going to come down to which doctor does the jury believe, or which doctor do they give more weight to? Because as you said, it's these building blocks, this timeline, this history of the defendant. acting in a way that will ultimately show that she doesn't understand the wrongfulness of her actions. And that's what the defense is going to have to prove here.
Yeah, and I think with all that history that we're going to hear, as you heard there in the beginning of the defense's closing argument, it's going to be very helpful to them in their case. Randolph, stand by. Before we go to break, I have an update for you in Texas, where a man originally set to stand trial starting today was sentenced to life in prison after pleading guilty. Just moments before his trial was set to begin, Darian Brown pleaded guilty to first-degree felony murder for killing 4-year-old Cash Gernon. A video obtained by the Daily Mail shows Brown abducting Cash while he was sleeping in his crib. Prosecutors say that Brown later stabbed the child to death about a half-mile from his home.
Initially, we had planned to go forward on the insanity defense, right?
Yes.
We really believed that we could win on the insanity defense, right?
Yes.
But after looking at some of the evidence, some of the other doctors' reports and things of that nature, you decided that you wanted to accept responsibility and plead guilty to murder. Is that correct?
Yes.
And you understand we could still go to trial, right?
Yes.
But that's not what you want to do.
That's not what I want to do.
Now, Brown was initially charged with capital murder, kidnapping, and burglary in the May 2021 death of Cash Gernon. At first, Brown was deemed incompetent to stand trial, but was later found competent after mental health treatment. Now, after Brown was sentenced to life in prison, prosecutors read 3 victim impact statements from Cash's family, including one from his father.
This statement is my son's defense and should be communicated a clear message. As a father, I would have given my life defending his. And from this day forward, my life will be spent carrying his memory in a way that will impact the lives of others. Initially, I was in favor of the death penalty, but my son's death wasn't painless or humane. You made sure of that, so now I'm opposed to you having the option to leave this world without first living out the days that you stole from my son, Cash.
All right, folks, we'll take that break. Still to come on Court TV, the defense finishes its opening statements in the Toddler stab murder trial of Bionca Ellis. Keep it here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala, now back to Ohio, where the Toddler stab murder trial is underway. The defendant, Bionca Ellis, is facing multiple charges, including murder and attempted murder in the stabbing death of 3-year-old Julian Wood. Now, he was stabbed in the face and back while his mother was pushing him in a shopping cart in June of last year. His mother was also stabbed, but she survived. Let's go back and hear more from the defense. They reveal more about her background, saying that her mental illness is to blame in its opening statement.
She committed that act in broad daylight, never trying to conceal the knife, and she doesn't run away. She walks away, knife in hand, still carrying the knife after this act is done. The evidence will show that there was no rational motive for her to have committed this offense. There's evidence will show that there's no relationship between she and the victims in this case. She still has a knife in hand at the time that the police confronts her. And she does drop it. Bionca's brought back to the police station, and eventually she's interviewed. There's evidence of mental illness that occurred as a result of her responses in that interview. There's evidence that will show that she was irrational at all points of time. During that interview, while in the jail, even when she arrived in the county jail, sitting naked on the floor. Bionca displayed mental illness from the beginning of this incident, for the months prior to this incident, while in the jail, and if by chance you saw her at her arraignment, the evidence will show that even during her arraignment, she was still mentally ill because she was smiling at the arraignment. The evidence will show that she answered the judge in Spanish when being asked questions. The evidence will also show that we had a difficult time communicating with Bionca. So much so that Dr. Sarah West became involved in the case. And she had to make an evaluation of whether or not she was competent to aid in her defense. And because her mental illness was still going on, Dr. West referred her to North Coast Behavioral. North Coast is a place where mentally ill people, they're there to get restored and for other reasons, but for Bionca's purposes, is for restoration, to get her competent so she can understand this process. So after the competency evaluation, Dr. West was requested to evaluate her for sanity. And the evidence will show that Dr. West did evaluate her for sanity. She looked at all of her prior psychiatric treatment over the many years since she was age 22, her behavior on the day of the incident, and all the other information that she took into consideration after. And Dr. West made a determination that she was insane at the time of the offense. You'll hear that evidence. But the state has a right to have their own doctor become involved. And Dr. Knopfsinger also made his evaluation, and he made the opposite determination. You'll have to make that determination based on the evidence that's presented in this case. You'll hear from some other doctors that dealt with her while she was at North Coast. And at the end of the day, you will have to make the determination. And I told you in the beginning during jury selection that she acknowledges through her lawyers, whether she testifies or not, that she's responsible for the murder of Julian. She acknowledges through her lawyers that she's responsible for the attempted murder of Margot. There's no running away from that. That's not what this trial is about. The evidence will show, though, that it is obvious that she was insane at the time of the offense. And no matter what your experiences have been, you have to evaluate that information. That's all we're asking you to do. Lastly, I believe that at the conclusion of this case, you will find that Mr. Johnson and I have met our burden of a preponderance by the evidence, okay? A preponderance of the evidence, and that burden is far less than what the state has to prove. Thank you.
Thank you.